All right, from hire to review best practices in employee management, it is my pleasure to announce our next presenter with a diverse two-pronged practice focusing on both private and public sector work. Chris Keenan advises clients in labor and employment and First Amendment litigation and in-house issues arising from the construction, energy, and hospitality industries. In all arenas, Chris provides a calm, practical, and seasoned approach to hot-button issues and routine matters alike. Chris draws on extensive experience to vigorously defend employers in lawsuits involving wage and hour issues, non-competition agreements, and claims of harassment and discrimination on the basis of gender, race, age, and disability. She also represents employers before both the Equal Employment Opportunity Commission and the Department of Labor. Please welcome Ms. Chris Keenan.
Good afternoon, y'all. I'm happy to be with y'all today. I know you've had a long day. Can y'all hear me okay in the back? Okay, good. So I'm Chris Keenan, and I work at the Kullman Firm. It's a labor and employment firm, and I've been practicing law for, going on 30 years now. And during my time practicing law, I've spent a lot of time representing public entities, and I will tell you, it is probably my favorite to do. It's just the most rewarding because everybody's so appreciative, the people are great, and the issues are about the most challenging. And so I feel you in terms of the issues you face and the challenges you have, because they are some of the most challenging in the employment world, I'll tell you. But they are the most fun from certainly a lawyer's perspective, and definitely fun to work through. Probably doesn't feel fun on your side. So today, I've only got an hour with you, and as I have mentioned before, we could talk about HR for probably 2 full days, because each topic and each issue is so complicated and requires a lot of discussion and covering lots of issues. But today we've got an hour, and we're going to hit 4 topics, and I'm going to go through those with you real quick so you can kind of see the roadmap about where we're going to go. And as I'm going through, I will certainly invite you all to ask questions as we go along the way. But feel free to raise issues or ask questions that may even be somewhat tangential to some of the issues we're talking about. I feel certain that if you have an issue that you're dealing with, others have it too. And I'm certainly happy to try to field any of those questions today, but I will definitely be stopping throughout the presentation today to ask you guys if you have any specific questions, but don't hold back. I'm happy to take on whatever you've got. So today we're going to talk about just some basics and sort of looking at it from the perspective of the employment relationship from sort of start to finish. In other words, bringing people on, what that process looks like. Once they get employed, how do you manage that relationship? How do you evaluate employees once you've brought them on, and some issues related to that, and then some payroll practices, and then some pitfalls to be wary of. And then, of course, making sure you're managing the appropriate documentation that you need to along the way. And then again, of course, I'm sure y'all will have some questions that are specific to particular issues maybe that you all have experienced, and I'm happy to navigate those with you as well. So those are the topics we're going to tackle today. Now, as we're talking about, all these different sort of practical issues about what you need to do in terms of, documentation and how you manage, hiring somebody and conducting evaluations, conducting interviews, all of these practical points and the advice that we provide, they're really governed by the requirements of all these different discrimination and employment laws that are out there. So the advice we give isn't just advice, based on what we think are good practices. It's really coming from what the law requires of you in some instances, and then also what we see happening once we've taken on a case and we've litigated it, what actually works and what doesn't work. But the laws are what sort of provide provide the framework of how we're doing these things. And there's quite a few. And typically I just call it the alphabet soup, right? Because as you all know, there's so many different laws out there. There's the ADA, the FMLA, the FLSA, the NLRA, and they've all got these different abbreviations. So, but that's the framework that we're operating under in terms of providing you with the advice. There's all these federal laws. Louisiana has its own set of laws that generally mimic what the federal laws are. And so those laws also guide how you make employment decisions in the workplace and what you can and cannot do. So as we're going through the presentation today, to the extent that particular laws sort of govern why and how you do things, we're going to point those out. But you all know, I'm sure, that under both federal and state laws, there are certain protected characteristics that guide how we can and how we manage employees. And so those are all dictated by statute. So traditionally we think of things like age, race, gender, disability, veteran status. All of those things are dictated by either a federal or state statute. And so we'll talk about some additional ones as well. Pregnancy being sort of the newest, where there are some additional guidelines. In Louisiana, we have some other additional ones that you have to be mindful of, including garnishments. You can't make employment decisions if somebody's got garnishments and if somebody's filed a workers' comp claim. And then you all may also be familiar with the Crown Act, which says that we can't make employment decisions based on somebody's hairstyle, and particularly what they call the natural protective or cultural hairstyles. And so that now is in our statute as well. And so that's a protected form of discrimination. And then Louisiana's also passed some statutes relating to medical marijuana. And so we'll talk about this a bit as well. The use of medical marijuana itself is protected only to the extent that somebody has a prescription for marijuana, and if they have a debilitating medical condition. So that's the only time really that you may run into this statute and medical marijuana is protected. But even in that situation, your normal drug and alcohol policy, which prohibits somebody from showing up to work intoxicated, still applies, right? So it hasn't changed that piece of it, but it may change how you manage any kind of pre-employment drug screening and that kind of thing. So those are some unique Louisiana state-specific laws that govern the employment relationship that you may be dealing with or may have to come to deal with in the future. So those are two that I wanted to make sure I pointed out. And again, we'll talk about these again as we walk through sort of the employment process. Now, that's sort of the overriding framework of the laws that govern how we do and why we do what we do in the employment process. So the first thing I want to talk about in terms of the employment relationship is step one, which is bringing in employees. How do we bring them in, when we bring them in, and what that recruiting process looks like and the onboarding process. And while that may not seem all that significant to you from a legal perspective, it is critical in processes you may have later on down the road. And so we'll talk about that, why this step one can be so critical when you're trying to deal with things like ADA reasonable accommodations or performance evaluations or even things like wage and hour issues. So this step one is probably the most critical step in the employment process that you can participate in. So let's talk about that and what needs to happen in this step one, which is creating the job description and describing what the job is. Now, from your perspective, sometimes when you think about the job description, you're just thinking about, I have a vacancy, I need to fill it. And so that's sort of the first step is, all right, typically when you're looking at this, you're looking at it because you're about to post for a job or you've got a job opening. And so that's perfectly fine to start in that way. And that's the first opportunity that you will have to look at this process and improve it if it needs improvement. And I'll tell you, just in my experience dealing with almost really, any company or organization, the job descriptions are always lacking. And so it's a place that really you should take a look at every time you have an opportunity to do a new hire. So when you're doing that new hire process and you've got a job that you need to hire for, first things first, you're going to post for the position. You need to make sure you have a good grasp of what the job is you're hiring for, and that you have a job description that accurately reflects the job, right? And so that means that you've got to talk to the supervising authority over the position to make sure that you have a clear understanding about what this job is going to do, what the person's going to do in the job, and what skill set is needed for the position. It is so often that you'll have a job description, you'll have HR or a recruiting function bringing people in and doing the interviews, but they're actually reporting and being supervised by somebody else. And then you'll find that the job description doesn't actually match what they actually then are doing. And so that disconnect can cause some real problems. So on the front end, when you're bringing somebody in, make sure the hiring person, the supervising authority, is involved in the process and is clearly identifying for you what the position is, what they're going to do, and what the skill set is that's needed for that position. And if there's prior work experience, that would be helpful for that position. So in other words, you want somebody that had previously worked in another, public organization before they come to you, so they have the familiarity with all of the uniqueness of what's required in a public agency. Then that would be something that you would also include both in your posting, but also in your job description. So make sure you're very clear about those things. Make sure you're clear about what the minimum qualifications are. In other words, the person we're going to hire for this position has to have this skill set or these qualifications, versus some that just would be desirable and the kinds of qualifications that might push them over, to make them a more desirable candidate. So those that they must have versus some that are just good. And again, all of that really becomes important down the road for these other sort of analyses that may take place down the road. And then also, while this may not seem important to you, it is also very important for later HR functions, is if there are physical requirements of the job. And you all may have already experienced that issue when you're dealing with like workers' comp claims or ADA issues where somebody wants light duty, or if they want some kind of an accommodation for their job. You've got to know what the physical demands are of the job, so you know whether or not a person coming off of workers' comp or some kind of leave of absence can come back to the job that they're in. And without that job description, then there's no way that a physician who's going to certify or do a fitness for duty is going to know what the physical demands of the job are. So you've got to make sure that that is set out in your job description. So that's why these job descriptions, although they're documents that we tend to sort of put at the bottom of our list in terms of important things to do, are actually unbelievably important for so many different pieces of the HR process down the road. So please don't overlook them. And, every piece of the job description is helpful. They serve a purpose in recruiting. They serve a purpose for leave of absence management. They serve a purpose for risk management, and they serve a purpose for employee evaluations. So you have to be mindful of that. So when you're doing your job description or your posting, again, even think about job title and make sure that your job title is as specific as it should be. And again, this may seem innocuous to you. So you may have a position that's bookkeeper or accountant or payroll manager or human resources manager. And those titles are so often misleading. And so you need to make sure that the title that you use is accurately reflecting the job that's the job that's being done. And if it's a specific kind of job, so for example, if you're looking for like a mechanic, is it a heavy machinery mechanic or just a general broad-based mechanic? All of those things again help for a variety of functions that HR is going to perform down the road, but also for your applicants for the position to know whether or not it's actually a job that they want. So be as specific as you can about those kinds of things. Now, writing the job description, so whose job is that going to be, right? Like, nobody really wants that job, but it needs to be done, and really it's an HR function more than it is anything else, again, because so many things from HR emanate from the job description. But make sure you're seeking input from the supervisors and also the folks who are the incumbents in the job, so people who are already doing it, to make sure that it actually reflects what they're doing. So make sure when you're doing those job descriptions, or if you're reviewing job descriptions that already exist, make sure that they identify the essential functions of the job. And I'm sure y'all have heard that key phraseology before. It's important to understand essential job functions versus what we call marginal job functions. So essential job functions are those job functions for which the job exists. In other words, if you're not going to do this part of your job, I really don't even need you to be in this job, right? This is why the job exists. And then sometimes there are job duties that somebody just kind of occasionally does if they have time and if the capacity allows. They're just marginal things that if they can do it, great. But there are some essential job functions. Let me give you an example. Coming to work on time. That's an essential job function, right? I don't think anybody would disagree with that. And the truth is, there's a lot of case law arguing about that, but that is an essential job function. Or, because of COVID now, we have a lot of remote work, okay? So people have adjusted their policies, and so we do see that there are some agencies and organizations that may only require in-person work 2 times a week. So if that's the policy that you now have implemented, that's an essential job function. You must be able to work in the office 2 times a week. So, that may have adjusted over time, but you see what I'm saying. There are certain things that in this position you must do. There may be some job positions that have to be in the office every day. And so that may be true for some specific positions, and then that needs to be an essential function of the job. Particularly, again, because we've kind of had this sort of remote work, hybrid work situation going on for a while. And, I think there's probably some fluctuation with that. So there needs to be some clarity about what those expectations are. And then there may be some job positions for which it is essential that a person understand how to use certain type of computer programs. So, for example, like Excel or maybe PowerPoint or things like that. If those are essential job functions because their job is either marketing based or accounting based or something like that, then those are essential job functions. In the healthcare world, there might be an essential job function that you can stand on your feet for more than 4 hours a day. So again, those are the kinds of things that if that is true for your position and it cannot be removed because that position is one where somebody's on their feet more than 4 hours a day, then it needs to be in the job description. And again, that's important for all those things that we talked about. If somebody comes back and wants light duty or an accommodation, you go straight to the job description and see what it says about what the essential job functions are. So that's where you want that. In the job description, you also want to make sure that it has, the elements of the particular job that are critical to the job, marginal job duties, expectations, reporting responsibilities, and then also this job description can be used by the supervisors as they're planning their performance evaluations for the next year, right? Because they can then use that as, okay, here's what the expectations are for the position, and they can match performance against that. Now, not a lot of people do that, but some do. Some use the job description as a way to set goals for the upcoming year. So if you have a really good job description that does sort of articulate what's the purpose of the position, here's the essential job functions, you can then use that document as a way to then extrapolate goals for each year. So a really good job description can really be very helpful to supervisors. So again, put some thought into those job descriptions so you can use it for that purpose. Now, in terms of what it must contain, and we've talked about this already, but the essential job functions, the important duties and responsibilities the reporting relationship. So in other words, this position will report up to. And again, all of that's important in terms of understanding who's reporting to whom in the organization. And that particular factor is important in terms of, again, discussions about wage and hour issues that we'll talk about, determining who's an exempt employee, salaried exempt or not exempt. It's important to know who's reporting to who. And then again, as we talked about, any mandatory requirements for licensure, particular degrees, certifications, all of that needs to be in there as well. So all of those things need to go in the job description. And as we talked about, the job description is sort of this key document, not only just for recruiting, posting, hiring. It's critical for some legal reasons. So under the Fair Labor Standards Act, which you all may be familiar with, that's the law that governs wage and hour issues and who gets overtime and who doesn't get overtime. The job description turns out to be the critical document in deciding whether or not somebody is properly classified as being exempt from overtime. So if you have outdated job descriptions that don't actually reflect what a person does in their job description, it makes it very, very difficult for you to defend a decision that you made that somebody is actually exempt from the overtime requirements. So you may have in your organization folks that you pay a salary to, and so because they're paid a salary, you make the decision they're not entitled to overtime. But the law is that they have to be salaried and they have to perform exempt job duties. And those exempt job duties must be reflected in the job description. So the job description has got to accurately reflect those exempt job duties. So I always find with public agencies that misconception. They always think that I just paid somebody a salary, I don't have to pay them overtime, and that's not how that works. They have to be paid a salary and they have to have exempt job duties, and those exempt job duties need to be reflected in the job description. So again, that's why you have to go back and check these job descriptions and make sure they accurately reflect what people are doing. Then the other thing we've alluded to with respect to the job descriptions is the issue of the ADA. And that's typically, you know, a situation where somebody has taken a leave of absence for some kind of a health-related issue, or a workers' comp leave of absence, again, a health-related issue, and it's time for them to come back to work. And the issue is they can't come back, or they need some kind of a modification to their job duties because they're physically unable to perform the job they were doing previously. And so then you have to go down this road of, do you have to offer light duty? What does light duty look like? Can you have light duty? And then under the ADA requires that you undertake this whole interactive process as to whether or not you can reasonably accommodate the individual in that position. And when you're discussing the issue of whether or not you can reasonably accommodate somebody, the first step is to pull the job description and look to see what the essential functions of the job are. And then you know that those essential job functions are the things you cannot and will not accommodate. And so that's your starting point for any discussion about reasonable accommodation. So workers' comp and ADA issues are probably, and the wage and hour issues are the two issues where the job description are probably the most important. And they'll come back to haunt you every time if they're not accurate. So make sure you take the time to update those and make sure they're accurate. And then, as I mentioned before, it's just an opportunity for supervisors to use those in other employment, decisions like setting goals and performance evaluations and whatnot. So I know that's a boring topic, but it's also a super important topic that I would hate for you all to overlook, and want to make sure you all get that correct. So before I move on to the actual interviewing part, does anybody have any questions about job descriptions?
I have two questions for you. The first one is, would you have a new hire sign a job description when they are hired?
Yes, so, and that's kind of up to you as to how you want to handle that, but many clients will take a job description as part of the new hire onboarding process, provide them with a job description and have them sign it, so there's no confusion about what their job duties are. Now, that only works if the job description is accurate. It's a great question.
And the next question is, what are some examples of exempt job duties?
Okay, well, so that's a whole hour long conversation. But so exempt job duties, there are various classifications of exempt job duties. So exempt job duties are they fall into different classes: executive, administrative, professional, highly compensated, computer salespeople, and outside sales. So in your world, you are most likely going to have the executive. You may have some professional, and you will definitely have administrative. So each of those is different, and each of those has a different set of duties. The executive is somebody who supervises 2 or more full-time employees, and they have the ability and authority to hire and fire. And so typically, an executive is your top dog. Like, you're not going to have really, you used to be like everybody kind of thought of themselves as an executive, but that's just not how it works. An executive is kind of the top person. And remember, they have to have the authority to hire and fire. So it's typically going to be your appointing authority, right? Then in the administrative position, the administrative one is one where you will have way more people in the exempt. So you're going to have a lot of people who are probably not exempt. But in the administrative position, it is somebody who has the ability to exercise their own independent judgment and discretion about a particular subject matter area that is related to the operation of the agency. So, for example, somebody that's in charge of HR. HR is a subject matter. Somebody that's in charge of accounting. Accounting is a subject matter. You might have somebody, while IT has its own exemption, it's really for computer programmers and software analysts. But if you had somebody that's in IT and over IT and supervises other people, they may meet the exemption if they are in their role exercising independent judgment and discretion as to how things are done. Purchasing, budgeting, procurement, those particular subject matter expertise, if you have somebody who in their job exercises their own independent judgment and discretion on those areas of subject matter expertise and are paid a salary, they're likely going to meet the administrative exemption. So those are the two that you probably will have most often. The professional exemption is really for people who have an advanced degree of some type. So it's going to be doctors, lawyers, RNs, not LPNs. So it's a very specialized degree. And then the computer exemption, as I said, is really for folks who are like computer programming, software analysts, that kind of thing. So there are very specific exemptions. And then the highly compensated exemption is for people who are making over, I believe, 110,000, something like that. And also exercise independent judgment and discretion, and also do one of the things that we just talked about. They have a subject matter area expertise. They supervise 2 or more full-time employees. So typically, if you have somebody in your agency that's making a significant salary and they have some level of supervisory authority, they're going to be exempt also. So that's a good question. But again, a whole topic. That's a whole hour-long conversation.
And I have one more question that came up. Does FLSA apply to all employers with more than $500,000 in revenue a year?
Yes, if you're, as long as you do some level of interstate commerce, which almost everybody does. So if you buy anything from out of state or get anything from out of state, or something comes in from out of state, then yes. All right, all good questions. All right, so then we'll talk about the interviewing process, and we'll go through this pretty quickly because I think most of this is stuff that you all probably know, and it's pretty intuitive, and you'll have the materials, so you'll be able to use this as a reference. But just be mindful in the interview process that when you're interviewing, again, using the job description as your guide, your questions must be job related. They can't. Our tendency, because we're such, outgoing, nice social people, our tendency is when we have somebody come in for an interview, we want to connect. We want to find a connection with them. So our tendency as people from Louisiana is, where are you from? What's your maiden name? Where'd you grow up? Where'd you go to high school? That's what we want to do because that's the kinds of conversations we have. And believe me, I know because, I get it, I understand it. But those are the exact kinds of conversations you can't have in an interview. And so everything you do in the interview process should be designed around what is the job, what are the skill sets we need for the job, and all your questions should be designed to find out whether or not they can meet those skills. Not whether or not you know them or know somebody that does know them, because inevitably that's going to elicit information that falls into one of our EEO categories. So just think about that, which means that before you interview somebody, which, for those of you that are really social people and good talkers, you might go into an interview and not really think much about it. I'm going to go in and I'm going to talk to this person, I'm going to see what they're about, without really probably spending too much time on the resume or the application and just go in there and talk. And sometimes that's a great way to learn about people, but again, you're going to get yourself into all these places you're not supposed to go. So what you really need to do is look at the applicant, look at the job description, and then think about the questions you need to ask, and then figure out, which is the hard part, how am I going to evaluate whether or not this person has the skill set I need? So sometimes it's something like, well, have you ever worked for a public agency before? Or this job requires that, you be able to work every other Saturday. Is that going to be a problem for you? Or this job requires, travel, 2 days a week. Is that something that you could do? That's how you have to do it. This job requires, will you be able to do that? Or have you had experience with that before? And as long as you keep your questions that way, you're gonna be fine. I will tell you one of the newest techniques that you all may have seen is this behavior-based questioning, so if that's important to you, in other words, and this may be for some of you who have jobs that are really public facing. So if you've got people who are going to be interacting with the public on a regular basis, and it could be in tense situations or even not tense situations, you might want to consider some of the behavior-based questioning, which is tell me about a time that you had to interact with a customer that was dissatisfied with their experience. How did you handle that? So you're trying to figure out from them, how do they handle different situations? And that's okay. So if what you want to know is, gosh, I wonder if they're going to be able to deal with somebody who's really angry because I can't do what they want me to do at that particular moment in time, or I can't answer their question, or I can't give them what they want, or they don't like the answer that I gave them, then ask those kinds of questions. Those are totally fine. They're hard if you're on the receiving end, but it does give you an idea about whether or not that person can handle the actual job. So think about those kinds of questions. So I'm just going to run through, a couple of things to keep in mind too, is whenever you're interviewing somebody, so obviously you're interviewing them because you want to know whether or not you want to hire them. But remember, in the interview, you're also giving them information about you and the agency. So you're selling the agency too. So you want them to leave with the impression of, I want to work there. So keep that in mind too. You want to be positive and upbeat about the agency itself and what it has to offer, so that the applicant leaves with the impression of, okay, I really want to get this job. And if they don't get the job, that they'll say to themselves, oh, I didn't get it this time, but I really want to try again next time. So you want to make sure you're giving good positive feedback about the agency and honesty about the job that they're actually applying for. And then, of course, if somebody doesn't get the position, we want to make sure we let them know in a timely fashion so that they have the kind of follow through that they need and know that you're that kind of an organization. So again, going through the questions, these are all in your materials about the do's and the don'ts, and we came up with a question for every letter of the alphabet, and I won't do that, but on age, I do want to raise one issue. So we talked about, the kinds of questions that you go in and you try to connect with people over. Here's one I think will throw you off, because I know it's one that we probably have all done. So you meet somebody for the first time and you're trying to figure out where they're from and where they go to high school. The question of, when did you graduate from high school? Or when did you graduate from college? right? You would think, because you're just trying to figure out, did you graduate the same time they did? Or did they graduate with your brother or their sister, your cousin, whatever? You're just trying to make the connections. Well, those questions actually are not great questions, because why? Age. Yeah. So that's how you have to think. You have to think about, are the questions going to give me information on a category I should know about? So that's one of the ones I always like to tell people about. Don't ask them when they graduated from high school. Maybe later you can. And then, of course, people always do. I get this question a lot. I don't want to hire somebody if I'm going to hire them and the next thing they know, they're going to be pregnant and they're going to take maternity leave. I mean, I can't have that, I need somebody that's here. I can't tell you how many times I get that question. You cannot ask that. So just pass right on by. Now, you can tell them if you're worried about travel or what the schedule is. You could tell them, here we have travel in our job, the schedule is this. The other thing is, sometimes in some agencies I've seen where there's a blackout period and there's no time off. You could talk about those kinds of things, but you just have to stay away from that topic. So, and just roll the dice. Everybody knows not to talk about religion. Here's one. In disabilities, everybody knows you can't talk about disabilities. So don't ask them if they're disabled or they've been sick. How many days did they off of work last year? Do you get sick frequently? None of that stuff. The F is for foreigners. So what's your name? What's your maiden name? What is that? Is that Italian? Is that French? Is that German? Where are you from? If you think they're not from here, none of that is acceptable. The other one I want to talk about, we talked about this already, is just, again, the criminal background check. And so I just want to go through that. Or we talked about marijuana. So I just want to talk about the so you'll see my K was, have you ever killed anyone? And can I ask about criminal background? So the answer is, you can ask about it. We don't have a ban the box law here in Louisiana, but we do have the fair chance law. And so under our fair chance law, it says that you can't consider somebody who has an arrest only if it also turns into a conviction. And I will tell you that had always been our guidance all along. So the EEOC under the federal guidance was always saying, you have to be really careful about how you handle arrest records. So generally, if you had ever asked an employment lawyer, they would have said, convictions really only. And now it's our law in Louisiana. So be very mindful. If you see somebody with an arrest, you cannot eliminate them as an applicant for that reason. You have to see whether or not it's a conviction. And then even after that, you have to decide, one, you have to look at how long ago it occurred. And generally the rule is 7 years. If it's, within 7 years, you can consider it. After 7 years, you kind of got to wash your hands of it. And then, is the conviction something that's actually related to the job that you're hiring them for? So somebody that was convicted of theft, or really the one we see is check writing. I forget what that crime is, but when they write the checks that are, fraudulent checks. And then they're applying for some kind of a job that's going to be handling cash or money. So that might be one where you might be like, maybe not. So you have to make sure there's some correlation. If somebody has a DUI and they have a conviction for a DUI, but they're not going to be driving for your job, they're going to be behind a desk, you have to ask yourself, is that really job related? Those are difficult decisions. I'm not suggesting they're easy at all, but those are the kinds of discussions you have to have before you make a termination decision or a no hire decision, and you should document that somewhere.
Okay, what if you run a background check, come back with a criminal record? State of Louisiana and some of the program like DHH prohibit people with criminal records from gaining full employment.
Yes, and that's fine. So where there's a program requirement in place, then that's going to be a bar in itself. But we're talking about jobs where there's no bar. So for example, like for a CDL, those kinds of things, there might be some regulations in place that say you can't have this kind of a conviction or arrest on your record. And so that would be your legitimate basis for not hiring somebody. So good question.
Well, my question may be more for Ms. Jennifer Shea. As referring to the conviction, if I have a bid that I have put out and a convicted felon bids on that solicitation, can I not awarded to him and deem him non-responsive because of that?
That's the answer. There's some statutes that directly deal with that issue, and you have to look at it very carefully because you have to know whether the conviction is final. If it's on appeal, there are some issues there.
And I can't remember, are these slides not in your hand? I know I added some slides there. Okay. Okay. All right, so I only have 10 minutes. Am I going to 3:10? Okay, good. Okay. All right, any other questions about the criminal background check? Because that's a newer law, and I know I do have to, provide advice on that issue kind of regularly because the analysis is very difficult. I'm not going to kid you. If that happens, it's just a hard discussion. So typically what I advise is if you do get some adverse information back in a background check, typically, you would send that information back to the applicant, say, hey, this came up in our background screening. If you would like to share any information about this with us, please do so, and give them a time frame by which they can contact you to share whatever information they want to share. Because sometimes it's unclear exactly what the situation is or what transpired, and so getting some clarification from them might help you make a decision. And then sometimes you don't ever hear from them again, So, but sometimes you do get some feedback, and that will help make a decision for you as to which way you go. And so I've had that happen before. And like I said, it's a difficult process to go through, but the law requires that you go through the process. So in some of these things, while we're talking about it here, sometimes the process is just as important as the outcome. So to the extent that you follow the process, make sure that you followed the process and you've documented that somewhere. All right, any other questions about that? Okay. I'm just going through some of these trickier ones. Gender identity, obviously you can't ask about gender identity at all in the interview process, so be mindful of that. And when it comes to things like restrooms and things, applicants are entitled to use the restroom for which they identify with that gender. So just be mindful to stay away from those issues. We've talked about nationality. Financial obligations. We touched on garnishments. So again, just be mindful in Louisiana that you can't make hiring decisions just based on the fact that somebody may have some garnishments. Passwords. This generally isn't going to come up in the interview process, but I do want you to be aware of this. In Louisiana, we do have now in the employment world a law that prevents employers from asking employees for their personal passwords, not their email passwords related to the employer network, but things like Facebook or Twitter or whatever other, Instagram, whatever. So you can't require them to turn those over. And I do have, it does happen that occasionally somebody will see something on Facebook or an employee will report another employee's activity on Facebook, and they want to know, can they go to the employee and ask them to go to get their Facebook account and show it? And again, those are dicey things to do. So an employee's personal Facebook account is their personal Facebook account, and you can't have them turn over their password to you as part of an investigation. So, all right. Tests, if anybody does tests, just be careful about tests. Make sure you're giving them to everybody in the same classification across the board. Of course, you can't ask anybody about race. We talked about drugs already and workers' comp. And then, of course, you can't ask these questions. So X, Y, and Z is examine your zipper, which means you can't ask questions. Are you single? Are you dating somebody? Comment about their attire. Or ask them out on a date. So I feel sure that all of you know you can't do any of that in the interview. Or take their phone number off an application and then call them later and ask them for a date. All those things would be completely inappropriate. Okay, and then in terms of the actual interview process, when you are doing an interview and you might have their resume in front of you, be mindful of the notes that you're writing on the application. Prefer that you don't write notes on the application, because inevitably what happens is you're trying to remember who these people are, because you're interviewing so many people. So you're trying to remember, okay, I got to remember who this person is. So I'm going to write down something identifying: glasses, or red shirt, and inevitably you're going to write something like old or, overweight. Those things are not going to work out well. So it's best to stick to, if you're going to write stuff on the application, which I prefer you didn't, write them on a separate sheet of paper if you have to write notes. And then those separate notes don't have to be retained. So if you write your thoughts on a separate, notepad, just so that you can keep your thoughts straight about who was who, and then you make your hiring decision, you don't have to retain the notes. The applications have to be retained, but the notes don't. And then if you do keep those notes, just make sure they're free of, any kind of commentary other than qualifications for the job and experience. So you just be very careful about those things. Applications have to be kept for 2 years. That's why you don't want to write on the applications. All right, any questions about that, applications or interviewing? It seems like such an easy process, but.
Can a company have a barrier crimes policy as part of the internal procedures that would deny a potential employee based on background?
Oh, what kind of, what?
A barrier crimes policy?
I don't know what that is. Does anybody else know what that is? A barrier crimes. Yeah, so like if there were just sort of a threshold of, that's what I was thinking. So could we have a per se rule that anybody convicted of these crimes are not going to be considered? I don't know that would work, because the law says you have to conduct an individualized, and that's the word, assessment. And so if you have a per se rule of any kind, it's going to violate the individualized assessment. So I don't think that's going to work. I don't think it'll work. I mean, it may be a practice, but again, you have to decide in each case. You have to look at the job the person's applying for and the specific conviction. So I just don't think a per se rule is going to satisfy the law.
And one more question. Are resumes treated the same as applications regarding records retention?
Yes. All right, good questions. All right, and then we'll kind of run through some of this required HR documentation. I'm sure a lot of this you all have and know. But, when you hire somebody, they've got to complete the I-9 process within 72 hours. And you all have to make sure that you are actually looking at the I-9 documents that they're turning in. And, we have to treat them as valid unless there's like an obvious, forgery on the documentation. We have an E-Verify system available if you want to use the E-Verify system, which does provide you with some defenses if you use it. So that's helpful. And then I'm sure you all also know that you have to turn into and report to the Department of Social Services anybody that you hire, and that will be put on your payroll. And that's for purposes of them being able to track down, child support orders and that kind of thing. And then, of course, hopefully you all are using the Louisiana employment notices, those posters, and putting those up in all of your offices. Under our Louisiana wage payment statute, there is a notice that must be posted under those, on that poster, which essentially says that we must tell our employees what their pay rate's going to be, when they're going to get paid, and how they're going to get paid. That we have to provide that information to employees upon hire, which obviously we would do in the offer letter to the employees as well, but it must also be posted as part of the postings that are done. Now, in terms of HR records, and this is also sort of consistent, I think, with the state agreed upon procedures. When you, when you hire somebody, you want to make sure you have their personal identifying information available to them, which is their name, address, home address, date of birth, the position that you're hiring them for, the work week and how the work week is defined. And that may simply be in the policies and procedures, but how the work week is defined. And then, of course, from a payroll perspective, you have to maintain how much they are paid on a weekly basis and when they are paid and what pay period it covers. So that should be on the paychecks as well and in the pay period. And And then for hourly employees, it's the same, but for all employees, you should be also keeping track of the hours worked and the days worked and the amount of leave taken. So make sure that you know that for all of your employees that you're keeping not only the basic personal information, the hourly rate, payday, what's paid each week, hours worked, and leave taken. And you have records that show each week what they worked, what their hours were, what leave was taken, and it was certified by a supervisor. So our state agreed upon procedures require that you do that. So that would be part of your regular record keeping requirements. Any questions about that? Nope, all good. Okay, you guys are on top of that. All right. So then the last 10 minutes we'll cover briefly just employee evaluations. So remember we talked about the job description, which is a useful tool in terms of doing employee evaluations. But keep in mind employee evaluations are both informal and formal. And I will tell you just from a litigation perspective, when we handle cases, the first thing we do if it's a discrimination case or even a harassment case and we have somebody complaining about how they've been treated, we want the file. We want all documentation. And nowadays, the vast majority of the documentation is informal documentation in the form of emails. So emails are also a form of documentation. So don't forget that. And even though it's not in the HR file, it's informal documentation, but it counts. And when you get to that point where you've decided you have just had enough with an employee and you're trying to figure out whether or not you can part ways, those emails are going to be very, very important. So informal documentation is very important, and you should make sure you're using it as a tool. And then, of course, there's the formal documentation also, which is then your performance appraisals. And if you do formal written warnings and counselings that go in the HR file, obviously those are very important. So there's both informal and formal, and so we'll talk about both of those. So what do you put in documentation? What constitutes documentation? Well, any kind of discussions about work assignments, in other words, if you ask somebody to take on a particular assignment that's outside of the job description, or how they handled a work assignment, good or bad, but generally we document what's not gone well. Any kind of informal counselings or coaching sessions. So if something didn't go well, your observations were that there could have been some improvements. And a lot of that can just be done informally by email. But it's very helpful to have that. And then, of course, requests for reasonable accommodations. So again, that's an employee who says, I need help with, I can't do this. So obviously that needs to be documented for sure. And then again, I said, any kind of complementary tasks, we're terrible at doing documenting the poor performance. So we're not documenting the good performance either. But that's worthwhile noting as well. And then, of course, if there's any kind of customer complaints or other complaints and disciplinary actions, and training is also very important. So if you do conduct any kind of training on a particular topic or issue, and of course you should be doing like harassment and discrimination training on a regular basis. And I know they do, so state agencies do LEO, but if you all are not doing anything like related to LEO and you have to do your own training, hopefully you're doing it and document that as well. But you may have other kinds of training that you need to do, attendance, safety, any of that. Make sure it's documented so you have a record that they did it. And so in terms of how you document, the important thing is that documentation is being done, because too often we will get to a place where it's time to part ways and there is no documentation, and then you can't act because you don't have any documentation. Because at the end of the day, you're going to have an employee who's completely unaware that they're underperforming, or suggests they're unaware that they're underperforming, and you don't really have any documentation to back that up. So documentation at the end of the day should go in any format by which it is easiest for supervisors to get it done. So if email is the best way, then do it by email. If the circumstances require that it be in a handwritten note because you just met with the employee and now you need to get it down and you're not in a place where you can send an email, or the employee doesn't have email, then do a note. But whatever it looks like and whatever's easiest to document it. Just get it documented. And make sure that the documentation reflects the facts and not necessarily how the supervisor feels, so that you're angry that you didn't believe the employee, or what your feelings were about the employee on that day. Just the facts. XYZ occurred. Johnny was late for the 3rd time this week. I spoke to him about being late. He didn't have an excuse. I told him that one more time and he would be fired. Those are the facts. So make sure all of those things are properly documented. Good documentation is force. Factual, objective, real time, consistent, and equitable. So real time means when it happens, not 3 months later when you've decided you want to fire them. So real time means the day you counsel Johnny, that's the day you're going to do the documentation. If not that day, it's okay if it's the next day, but I mean real time. Because again, the problem is 3 months later, you've had it with Johnny and you haven't documented. So now all of a sudden you want to document it. Well, that's not going to work. So make sure it's real time and make sure it's consistent. So in other words, that your documentation, you consistently, what you're writing up Johnny for, you write up other people for. And what you've written him up for has been consistent across the board. Now, and factual, as we talked about. Now, what do we mean by being equitable? The most important thing about being equitable is to make sure that the offense or observation that you have and your response to it, they fit. In other words, that the punishment fits the crime, right? So you don't want to have a situation where Johnny's late one day and then you fire him on the spot, right? That doesn't seem like an equitable outcome. And remember, some of this, if you think about it, is, while in the moment, you're just dealing with the moment. If Johnny were to decide that he felt like he was treated differently than his coworkers and decided that he wanted to sue, now you have an optics situation. How would a jury view that decision? Would they think it was overly harsh? And if so, how are you going to explain yourself? So try to remove yourself from that perspective and just say, okay, is my response appropriate for what the issue is? So think about that. And typically when we're counseling somebody, you do want to give them an opportunity to ask them about why something occurred, or here's my observation, here's what I'm seeing, and here's the impact that I'm seeing. Can you tell me what you think? What's your perspective? Is there something going on that I can help you with? So that you give them an opportunity to give their perspective in case there's something going on that you don't know about. And then that's what allows you to be equitable. So as long as you're doing all of those things, then your response and your counseling is ultimately going to be perceived as being equitable. Now, that being said, you have to make sure that you treat everybody the same. So however you treat Johnny, who's been late 3 times, you're treating Susie the same, who's been late 3 times, if their circumstances are the same. So be sure, and I always say this to clients when they call, when they ask me about a particular problem, they say, we want to do X, Y, and Z. And I'll say, well, how have you handled that before? You want to make sure you're being consistent. All right, and so objective things are things like attendance, punctuality, performance. Behavior, when we say behavior, it's like things like safety. Not Johnny came in grumpy today, but things like that. Subjective things are things like he was difficult, he had a bad attitude, he wasn't a team player, he didn't have enthusiasm, because those are based on your subjective perception. So be mindful of what's an objective observation, what's a subjective observation. Now, in terms of having these difficult conversations, so here are just some thoughts in terms of, because it's one thing to see it, and then for you to write it down, it's another thing to have to tell them about it, right? That's the hardest part, is telling them. So how do you tell them? So just here's some points on how to do that. Is, to define the problem based on facts. So instead of saying you're always late, say, hey, I've noticed this week that you came in late Monday, Tuesday, and Thursday, and that was my observation. So it's just, so you're giving the facts. And then you can say, look, when you come in late like that, what happens is your coworkers are having to answer your phone all of the time in addition to their line, and so they're having to do double duty. So it's causing a little bit of stress on the team. And then you just say, hey, so is there something going on that we need to know about? What's happening? And give them a chance to sort of explain it. And then you just say something like, you have to try to get everybody on the same page. And how often does this happen? Like almost never, but you try. And you just say, look, well, can you understand with me like how this is kind of a difficult situation, for your coworkers or for me or, for the organization if you're not here, 3 days a week, because now I got to find somebody to cover your shift and it's kind of putting me in a bind. I mean, so that's where I'm at and why I'm struggling. And just try to get them to understand what the issue is, and then just say, hey, look, I'm thinking that this is what needs to happen. I need for you to commit that you're going to be on time every day this week, or try to get them to buy into what the story is, and then try to get them to agree. So as long as they feel like you're listening to what their side of the story is, sometimes you can get alignment. But even if you can't, you just need to make sure you get them to understand this is their behavior. This is what you see the issue is, and this is how you're going to respond. So, the tools, of these ideas of how you phrase it is just sort of an approach. But at the end of the day, you want issue, response, solution, and agreement. Okay, we're right at 3:10. So these are just helpful phrases that I put in here to figure out how to have the conversations, which are never pleasant. We talked about the documentation. And the most important thing before I wrap up is just to say, make sure that before you give any kind of a counseling or termination at worst, that the employee has noticed beforehand this is coming, unless it's a really egregious issue, like a violation of the discrimination or harassment policies. But if it's something like tardiness, performance problems, they have to have notice before termination comes. So you always want to make sure they are aware that, hey, this is the last chance. And what's that? I did. I don't remember which ones I added.
And the new slides will be posted on our website.
Okay. Yeah, I was saying I did a supervisor training last week, and they asked me about things like, well, how do I have this conversation? So I added those slides in. And I can't remember what other ones I added, but I think that's it. Okay, so any questions? I know that's a lot. I'm telling you, this topic, we could go all day on this topic. You have a question back there? I can't hear it. Oh, yeah, so what does it mean to be an at-will state? Well, it means that, technically, being an at-will state means that as the employer, I can fire you for any reason, good reason or bad reason or no reason at all, and the employee can leave for good reason, bad reason, or no reason at all. That's what that means. But in practice, that's not actually how it works. So all those laws that I listed for you at the beginning, those are all exceptions to the at-will rule. It means you can't fire somebody because of race, gender, age, veteran status, disability status. And so all of those things are what guide how we treat the at-will status, if you will. Good question, though.
Okay, so in light of the age discrimination and that sort of thing, thinking about that, you have a hypothetical employee that you hire, and 8 years ago, he's a great hire, everything's fine. He was hired to weed eat and cut grass and that sort of thing, physical labor, but now he's no longer able to do that. How do you handle that?
Yeah. So those are very difficult situations, and you cannot, so you can't make an employment decision based on age. So all you can do is continue to tell him, look, these are what the expectations are, and make sure he understands and whether or not he can perform them. And that if he cannot perform them, so for example, if there's a quantity, you got to do this much in a week or whatever, that he's continuing to meet those quantity and quality requirements. And every time he's not, I'm saying it's a he, it could be a she, that you're documenting that. Because you can't say something like, are you still able to do this? Now, if something happened like he had a week where he was doing a lot of outside labor work or any kind of heavy labor work, and then by the end of the week you noticed that he was taking a lot of breaks, and or he had to leave to go home early because he was exhausted. All right, so if you observe behavior which ultimately, like you have a concern about physical condition, then you could say you have an observation and you say, hey, I noticed that this happened. Is there something I can help you with? Or if you start to be concerned about whether or not safely they can perform the job, then you might be able to do a fitness for duty. And that's a very, specific process. But if you start to observe behavior where you're like, I don't know if this is safe anymore, then you observe those behaviors which lead you to believe it's not safe, and then you might be able to do a fitness for duty. It just kind of depends on the circumstances. But, I've had some situations like that where we've, done it that way. So that's a very delicate situation, but that's a good hypothetical. Okay. All right, guys. Look, we could go on for days, but I think my time is over, and if I don't stop talking, then the next person won't be able to have any time up here. So I'll stay around after if you guys want to come and ask me questions, and I'm happy to answer any questions you guys have. All right. Thank you.
All right, we're going to take a break for the next 5 minutes, so let's be back at 3:20.